Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor as we talk about the order after hearing on a motion to cancel or set aside a judgment of parentage, also known as Form FL-278. As with all our court forms, you want to fill out your identifying case caption information at the top. Below that, you are going to list if the hearing took place as an uncontested hearing. In other words, there was an agreement reached by stipulation if there is a written agreement reached, or contested, meaning that the two parties did not reach an agreement and the judge had to make a decision. You want to list below that the date the hearing took place, the department, and the name of the judicial officer. Then you want to identify all the parties that were present, so check the boxes that identify those parties. If there were any attorneys present, you want to mark the box next to the party for whom the attorney was present for and write out their name as well. If there was a guardian ad litem present, in other words, an advocate that's been appointed by the court for the child, you want to mark box 1F and list that guardian ad litem's name. If there was an attorney for a local child support agency present, mark box 1G and list that attorney's name. If there's any other person that had a significant role to this case that was present at this hearing, you want to mark 1H and identify who that person was next to the word other. Next, you want to indicate in line 2 the names of the parents that have been previously established to be parents of the child or children at issue. And then in 3, you need to list the facts that existed at the time of the hearing, the name of the child or children at issue, dates of birth, whether a genetic father has been established for that child, whether there was a judgment on parentage for that child, and whether there was a filed declaration of parentage or paternity for that child. Below that, if the court makes a finding at the hearing that the voluntary declaration of parentage or paternity was void or invalid for any of the children, you would mark box 4 and identify which children they found it was void for. And then other, if there's anything else pertaining to something that occurred at the hearing that you think is significant, you would list that in 5 other. In item number 6, you're going to list the findings that the court made. So for each child that is at issue via this notice of motion, you're going to list that child, their date of birth, and then you're going to indicate if the judgment of parentage was canceled or set aside, yes or no, or if the voluntary declaration of parentage or paternity was set aside or canceled, yes or no, or not applicable if that wasn't even something that was brought up. If a judgment of paternity was canceled or set aside, this paragraph below states that any child support that was ordered for that child has also been vacated. And if, again, above a judgment of non-parentage is granted, you would want to mark J and identify which children it was granted for. I know this seems a bit redundant, but you just repeat the same information as above here. If the court ends up denying the request to set aside or vacate the request to set aside the judgment of parentage, and mark box K and list which children the court denied that request for. If the court ends up denying the motion to cancel or set aside the judgment of parentage, then in item 7, we're going to list the reasons that the court gave for that denial. So it could be the age of the child. Maybe the child's just too old to do that too, and if that's the case, then you would list what the age of the child is. 7B, if it's been too long since the entry of judgment establishing parentage, identify for 7B what that time period is. If the nature, duration, and quality of the relationship between the previously established parent and the child was a factor, then you would mark 7C and include as well the duration and frequency of the time periods during which the child and previously established parent resided in the same household or enjoyed a parent-child relationship. If the previously established parent has requested that the parent-child relationship continue, and that's the basis for the court's denial, mark item 7D. If the genetic parent of the child does not oppose preservation of the relationship between the previously established parent and the child, so in other words, if, for instance, the mother wants the person that's been found to be the father to be still continue to be listed as the father, mark 7E. If the court found that there was a detriment to the child, if the genetic parent was established as the parent, mark 8F and explain any other details the court might have given about that. If the previously established parent has hindered the ability to discover the identity of or get support from the genetic parent, mark 8G, and again, any details that the court provides with respect to that. If there are any other factors concerning the best interest of the child that the court elaborates on, mark 8H, and you can specify what those factors are over there. If there was if the declaration of paternity was set aside, then item 9, the court may order that the court clerk has to send a copy of this order to the Department of Child Support Services, provided that they're involved in the case. If that is the case, mark box 9. If there are any other orders with request to this, or I'm sorry, with respect to this motion to set aside hearing, you would identify those orders in item 10. If there's any attachments to this order, tally up the number of pages listed below. And then this form is going to get sent to any other parties that were at the hearing. So if there was if you're the petitioner and the respondent was at the hearing, you'd send it to the respondent for approval. If there was a guardian ad litem for the child present, you would send it to them for approval. Mark their role to the case, and they will sign where indicated. And then once you get this form back signed by all the parties that were present at the hearing, you can submit it for processing at the courthouse. And once the judge stamps it at the bottom, then it becomes an official and enforceable court order. So I hope you found this helpful. Good luck.